So the floor is
Before we
yours.
start, sir, Mr. Chairman, might I inquire of you, just as a bit of background, why was it that other presenters have, I recall one of the government representatives made a presentation for almost 2.5, almost 3 hours, and individuals who are responding are only limited to 10 minutes. I wonder.
Sir, Mr. Weeks, we have rules.
Just let me
Mr. Weeks,
let me
hold
finish.
on. Your 10 minutes has started. We have rules, sir. They're
There
the
you are.
rules we set.
Even there. All right.
And this is the Parliament. The Parliament of Barbados makes its rules. Can you state your name for the record, sir?
My name is David Weeks.
Okay, and what's your occupation?
I am a retired individual.
Okay, sir.
A role
I just wanted to be clear, sir. You said in requesting
You limit my time,
permission.
Mr. Chairman. Am I going to be allowed to present for the 10 minutes?
No, sir. Hold on, sir. Your 10 minutes. Yes, sir, I said that. You said in your request for an oral presentation that you live in exile. And
Yes.
I just wondered what is meant by that, sir, because, I mean, I thought we're a free society and you're living in exile. So I just wanted you to clear on that. What do you mean by living in exile, sir?
Mr. Chairman, just to be clear, I want to know whether that query can come after I make my presentation.
No, your 10 minutes hasn't started yet, sir. So just
Thank you.
For the records, what you mean by living in exile, sir?
I live in a circumstance where, having been firebombed in Barbados for a particular matter, my matter being that I brought the governments of CARICOM, 13 governments of CARICOM, to the law courts of Barbados, and sought there afterwards to get a trial to proceed for 17 years. Then I found myself firebombed. So I live in exile because I do know that if I do come back to Barbados, I will either be incarcerated for the different things that have been constructed to make sure that I find myself in prison, or I will be killed. The first attempt failed, the firebombing failed. So I'm here living in exile because of that explicit reason.
Okay, Mr. Weeks, the floor is yours.
Let me just start by saying you would be very familiar with a quotation from from Romeo and Juliet, "A rose by any other name would smell just as sweetly." And what is presented in that statement is that what one says and the actuality, irrespective of what is projected as an outcome, what ultimately obtains is defined by virtue of the outcome. Quite simply, it looks like a rose, it smells by a rose, but what we are being shown here are the petals of the rose. I'm among many individuals who would caution Barbadians and reviewers alike to consider the petals of this rose that is being presented to the people of Barbados under the context of cybersecurity bill. There are some words here that masquerade within that bill, and attention should be brought to those: annoyance, inconvenience, embarrassment, insult, humiliation, intimidation, and anxiety. For on the one hand, there are justifiable issues that the bill addresses, namely illegal and reprehensible acts that require the enactment of laws to protect the rights of citizens, politicians, and the such like. I guess politicians are a subset of the citizens of Barbados. But I respectfully suggest that the new republic in proposing state endorse threats, and it both denies the rights of the freedom of speech. Forgive me saying freedom of speech, I should say freedom of expression, because freedom of speech obtains here in the United States. freedom of expression is what obtains in Barbados. The Budapest Convention has certain provisions, and by extension, the Cybercrime Bill purportedly established based upon the Budapest Convention gives those three categorizations of substantive law, procedural law, and international cooperation as the matters related to cyber crimes. But reviewers will see how definitely the reasonable parameters of the Budapest Convention are exceeded by our indigenous cybersecurity bill, particularly as defined by Clause 20, cyberbullying. Under 21, if we read in part, and I will just give an excerpt, a person who intentionally uses the computer system to publish, broadcast, or transmit data that is offensive. And I'm going to put those words which are important for my representation: offensive, pornographic, indecent, vulgar, profane, obscene, or of a menacing character, or causes any such data to be so sent for the purpose of causing annoyance, inconvenience, danger, obstruction, embarrassment, insult, injury, humiliation, intimidation, hatred, anxiety, or causes substantial emotional distress to that person, and the bill continues. You all have it in front of you, and certainly anybody can read it and so forth, but I'm making focus upon those particular words. I respectfully suggest that there's a disingenuous concatenation of these words being relied on here. The blindest man on a trotting horse can see what the words danger, injury, and hatred can refer to. But consider those other appended words in the lesser, indeed even puerile impact: annoyance, inconvenience, embarrassment, insult, and said other vapid terms. I respectfully suggest that there is a disingenuous concatenation here being relied on. The bill has been purposely mentioned danger, injury, and hatred with a hodgepodge of words of lesser, indeed puerile import. And I wouldn't go over them again. I know that you all are familiar with them. You all wrote it: annoyance, inconvenience, embarrassment, insult, and similar words. These delicate, emotional, and sensitive words, which are not criminal acts, but like the privileged exchange of your mother uttered in the lower house, might at best be subjectively inflammatory. And it raises the question of why have they been included and added here? I am reliably informed, not to say begs the question here, but rather it raises the question. It raises the salient question: why are these words so purposely being intertwined? Why use danger, injury, hatred with annoyance, embarrassment, insult, or inconvenience? And I will attempt to answer that same question and say that this concatenation is purposed to create a situation where its artful juxtaposition will be used by parties who seek to entrap the victims of the Republic. Now, let me repeat that part: the victims of the Republic. No defendant charged under this law will be able to delink those emotive words and will find themselves incapable of decoupling danger and injury from their charges. And in anticipation of upcoming questions, I expect that the question will be posed about if I want to delete injury and danger from the bill. And I preempt that question by saying no, but I suggest respectfully that as the bill is purposely written, citizens have to check all the words or none. And therein lies the petals of this cybersecurity rose, of any other name, Mr. Chairman. The subtle undercurrent of this bill is that it ostensibly states that Barbadians are free to transmit data as long as it does not defame others. But more specifically, while defamation is provided for in existing laws, this now includes a purpose plurality, expanding on the plurality of unnamed distresses appended to catch any and all dissenters. In a recent exchange, I remember another presenter, hypothetical example of defamation, made the statement where a fellow would call another's mother's a prostitute. I believe it was you, Mr. Chairman, who talked about given an example of the mother being a prostitute. So in a tangential vein, I would like the committee to consider this example, which won't use the vulgarity that other member of the House directed to another member, referencing the other mother's parts, underprivileged, of course. But let me give you this tangential banter. Suppose you and I, Mr. Chairman, we were to attend a hypothetical nightclub, and you or I spread news of the other individuals' dalliances to third parties. One is led to wonder if that truth being shared to third parties, while not causing danger or injury underneath the bill, but causing annoyance, embarrassment, humiliation, and generally discommoding either of us, if that will be given the expansive or if given the expansive definition of this cybersecurity bill, it will activate it and cause either of us to be brought before the Barbados courts by the other aggrieved party because of embarrassment, because of annoyance. For such a query, I would answer yes. And I will go on further to say this, that depending on who we are as the aggrieved party, because of the puerile emotive conditions expressed within the bill, as the aggrieved party, notwithstanding the truth of your seeing me in Frontline or any of those nightclubs, I can easily seek to bring my matter, or you can easily bring your matter before the court. And though you only embarrass me, and you or I can find ourselves guilty of the immature provisions of the Barbados Cybersecurity Bill, because my remarks are offensive. Listen to this, 7 years or $70,000 because I offended you or you offended me. And our nation has been silenced from any type of dissent. So this bill has used two deft concatenations which commingle legal issues with subjective feelings claimed by an aggrieved party. For example, a politician or them friend, parties now protected by Barbados' equivalent of Thailand's lèse-majesté, enacted by a sympathetic magistrate. I beg your forbearance, and this is where I really and truthfully had wanted to make to close. I wanted to close and give a simple example to underscore how this fickle annoyance condition under the imminent cybersecurity bill can be enacted. So if I could, from this point of view, I need your assistance, your IT team's assistance, just to make something come on stream, and then there afterwards tie in the offense, tie in the issue of how someone can be annoyed by something that is that underneath this particular law, and can seek there afterwards to put me in front of a court, or anyone who in similar vein seeks to make representation or express an opinion which is not a popular opinion, but merely because of what you are presenting, it causes annoyance, it causes insult, it causes injury, or humiliation. I wondered whether the committee would allow me to make representation here and do that, if only for a couple of seconds. I don't know how much more time I do have, but I'm finished on this particular point.
Mr. Weeks, I'm not exactly clear on what you're asking us to allow you to do.
I'm asking you to share my screen.
So don't you have to share the screen, sir?
Well, I was just asking for your IT team to give me assistance in sharing my screen. That was what I was told in the email. I was told in the email from you that the IT team will give assistance in sharing the screen. will give direction and assistance. Zoom is controlled by the IT department. So just mention that the committee and they will assist. Does that not still obtain?
Mr. Weeks?
Yes.
My understanding is that in the Zoom, there's an option in the Zoom that you go and you share your screen. And once you do that, it will show up on our end.
Okay. Share. Photo. Very good. Is that being shared with you?
Yes, it is there.
Good.
But Mr. Weeks, we're not going to allow you any such sharing. We're here to discuss the Cybercrime Bill and the Mutual Assistance in Criminal Matters Amendment Bill. So we're not allowing this, sir. Hold on, sir. So your presentation, please take that off. Is your presentation at an end? I need to know on the bill itself, sir.
Yes.
That's what we're dealing with.
The point that I was finishing on is on the bill itself.
Yes.
Where someone makes a transmission via the computer, and underneath the cyber security bill, someone makes a presentation. And when they make that presentation or they transmit this information, it causes an individual, it causes person, I realize you won't have yours on a relay, but it causes someone who receives this to feel annoyed, humiliated, and those puerile words, that is what I would like to be able to address. I made this specific representation to say that yes, where there's danger, where there's injury, where there's defamation, Cap 199, 1997 provides for those things. But to the degree that there is an aspect where someone makes a representation that brings in those other verbs, those other words, annoy, humiliate, and the such like, Mr. Chairman, that those are the 2 points I wanted to make here. One, to indicate that you do have situations where, when interpreted by particular parties, can and will be interpreted in such a way which denies individuals the right of free speech and free expression. Free expression. Let me say free expression because I heard one of your colleagues at one point in time, one of the committee members say that there was no such provision underneath the laws of Barbados, but free expression is provided for underneath the laws of Barbados. And on that note, Mr. Chairman, I'm sorry to have mentioned things about frontline and so forth. No, I do not mean to intend any affront to anyone if I have mentioned things that would be disturbing, but just to make those examples. There's one final point. We are moving very slowly towards Thailand's lèse-majesté. As nicely as this thing is patterned, as nicely as it is presented, as I said, a rose by any other name would smell just as sweetly. These verbs and words are the petals of that rose, and I would beg that greater consideration be given for this bill, it be rescinded, and a new bill be presented that is much more harmonious of the rights of free speech and free expression of Barbadians and citizens and persons and residents living within the fair country of Barbados. Less we may prevent. And on that note, Mr. Chairman, I thank you very much for allowing me to make this presentation.
Thank you, Mr. Weeks. Any members wish to engage Mr. Weeks on anything he said or otherwise?
Yes.
Yes, Honorable Leader of the Opposition.
Hi. Good morning, Mr. Weeks.
Good morning, Mr. Thorne.
If you called me Ralph and I called you David, would we still be allowed to go on?
I'm not sure. The chairman will decide as to whether we will be able to speak in that particular way. But I will address you as Ralph. If that is allowed by the
Yes.
chairman, most assuredly.
Yes, I make bold to say that for both of us, this is a personal delight. Yes?
Yes.
Good. I wanted to ask a few questions because for me, this has become a process of my own education. And that's why I'm pleased that someone of your quality has visited the presentations. So I'm going to ask some simple questions so that at the end of this exercise, I would have a clearer idea as a committee member as to what is the substance and essence of the objections. I think I know what they are, but I want to seize this opportunity, David, to inquire of you by a few simple questions. I take it you are opposed to the bill?
Very much so.
Good. And I take it you are aware that this law, in its form as drafted here, has been passed in other jurisdictions. I don't ask that to excuse what is being done by this Parliament. It's a series of questions that I think is probably the Socratic method by which we will arrive at some answer, ultimately, as to whether the bill has merit or not. So I'm just asking, permit me to ask these questions so that the discussion and or understanding of the discussion will make some progress as between all of us. So these are simple questions. They're not tendentious in any way. I just want to be able to come to a settled view, not as to the nature and content of the bill itself, but I want to come to a view as to what is the protest, what is the nature of the protest out there in the public. That's what I'm trying to do. So I'm not being tendentious. I'm just seeking what is the state of mind of people who object. You following me, David?
I am following you, Ralph.
Good, good.
I would not be presumptuous to speak on the public, but within the small cadre of persons who I converse with, both within the diaspora and there in Barbados, the concern is not so much the ambit of the law that other countries that have passed this law, the other countries that have passed this law, that they have made provisions for, but more so the subtlety within which if I have offended you, if on by mere the substance of something that is conveyed via the computer, and that's why I sought to use that particular example that I provided, that the chairman asked to be taken down. I sought to say, if the sentiment of individuals is that their rights and their privileges that were normally part of these fields and hills beyond the recall in Barbados, they're seeing that they're being taken back, that if someone opens their mouth and says something like Mugabe land, and it compromises a little mean, you can actually see, or maybe I should ask the question, do you not see Ralph, who Casey, the chairman did in actual fact give you the KC as opposed to the SC. But do you not see where there is room for an interpretation or misinterpretation where such a mean could be brought into the court because it causes annoyance, it causes humiliation, and
we're always entitled, I'm sorry, we're always entitled to subjective interpretation. The court ultimately has that duty. I want to say to you, David, that there's this saying, 2 wrongs don't make a right. So don't allow that to influence your answer. And my question to you had been this: how does it appeal to you that other countries may have or have in fact passed similar legislation? How does that influence your argument? Are you going to say two wrongs don't make a right? Are you going to say that there are peculiar circumstances in Barbados that militate against the passage of this law? Keep an open mind on it. I certainly have an open mind, I can promise you that. And some of the protestations and objections I find highly persuasive. And it does not matter to me that other countries have passed the law. I'm concerned about the passage of the law here. So I'm asking you, how does it appeal to you that other countries have passed the law? Will you say two wrongs don't make a right? You're muted? Oh, sorry.
You got muted. You got muted just now.
Oh, I beg your pardon. I was asking you, how does it appeal to you that other countries have passed this legislation?
My position is this, Ralph. While other countries have passed that legislation,
Yes,
I do not believe that that weighs upon a Bajan, a Barbadian, any Barbadian who has come up in Barbados where our navel string buried should not be subjected to such a pernicious law, which by cover of night is taking away the basic rights of individuals to speak, because what I have been hearing is that when you are within groups of individuals speaking in the context of Barbados, now there's a fear merely to write something within the computer format, because individuals can send that to a third party and it be construed, if the law is passed, it be construed as a chapeau underneath which individuals can be can be prosecuted under that law.
okay.
So I'm not really interested in what happens elsewhere.
Right.
I believe that as Barbadians, we have a right to preserve
Or cherish freedoms. Or cherish freedoms.
Our cherished freedoms.
Right.
Yes.
Okay.
Yes, Ron.
All right. The other question I want to ask is this, and I think we're leading up to this point, and perhaps you have said it yourself, that law must exist in its own peculiar culture, and let me say in its own peculiar political culture. That if you have a culture, well, you have this law, which is which allows a prosecutor to be fairly selective. You following me?
Yes.
The offense,
Yes.
any criminal offense, the offense of murder takes place, you know who to charge, the murderer. Breaking and entering takes place, you charge the person who broke and entered. Sexual assault takes place, you charge the molester, the sexual molester. This offense offers to a prosecutor the opportunity to be widely selective, or let's say to be selective. Because as I've said in here on the last occasion, this offense, these offenses take place every minute of every day. And you're not, just give me a second, please. You're not going to charge 50,000 people who go into cyberspace and commit the offense. And therefore, a prosecutor has the opportunity to decide who he will charge, who he or she will charge. Yes? Yes. Is that a concern of yours? We know that, we all agree that assaulting people in cyberspace is wrong, and that there should be some sanction against it. Is it one of your difficulties with the legislation that it permits the state to select those against whom it will charge? Is that one of your concerns?
That is my main concern.
That's your main concern?
That is my main concern.
Right.
That it has been reduced our laws in Barbados, a place which has come through so much, where our forefathers, well, particularly as we consider the period prior to, just prior to, and following our independence in 1966, we are moving far and very far away from what the forefathers perceived or what Arab perceived, and those individuals within that cluster perceived as these fields and hills beyond we call are now our very own. This law or that particular, those clauses, those verbs within there, they expressly allow for individuals to take away those rights and cherished freedoms. That is what I think, that's what I'm seeing there. A colleague called me some months ago when this was being contemplated, and he says, you have offended the powers that be. Why is it that these two things are being so aggressively pursued? And I said to that individual, my matter of 17 years, when I recognized that I have not been able to get a day in court, I said that the only place that I can go to is to the United Nations. Now, before we go any further, Brother Ralph, when I say United Nations, I am speaking about the United Nations Human Rights Commission, not the United Nations Secretary General. So let there not be a situation where people are saying, making a comment about that particular position. So you got your rights abrogated. You no longer have rights underneath the court system in Barbados, and you reach out to the United Nations Human Rights Commission. And that in and of itself causes further problems. So I would respectfully suggest that when an individual such as myself will continue to make representations to those bodies, will continue and will not pause in making those representations, that can cause certain parties to be offended. And that is the reason that this law is being pushed with such alacrity.
David, have you looked at the Computer Misuse Act, which is on the books and has been so for many years? By way of comparison, have you looked at the Computer Misuse Act, which I think this legislation will repeal?
Yes, but look more carefully. You're not necessarily looking at the improvements, because let me just say that...
Just let me develop the question. And the question was this: do you consider that the Computer Misuse Act has served its purpose or has outlived its usefulness? Pardon the cliche, has outlived its usefulness.
It has, because the issues
short question, short answers. I don't think the chairman will allow us too much longer. So that if it has outlived its usefulness and that this legislation is intended to replace it, do you consider that this legislation has gone too far in potentially trampling the rights of citizens?
Yes.
Yes.
Most assuredly, yes.
Most certainly.
It has addressed the fact that the environment with computer abuse has totally changed from when those laws were passed. But in its enthusiasm and zealousness of particular parties, it has divided itself. What is the word? I forget the term about where reason divides itself from justice. It becomes over anxious, it becomes over expressive, over enthusiastic, ultra virus.
Yes.
It is now going into an area where it is saying, yes, these things need to be addressed because these have changed. But while we are at it, let us also look at seeking to keep individuals from speaking anymore. They can't offend anyone.
Yes. Now, sometimes we, and when I say we who are politicians, say things rather unwittingly. And the chairman may not mind that I remind us all that he made reference this morning to politicians. And I've heard that more than once, this possible view that this legislation may be intended to offer some additional protection to politicians. I haven't heard anybody say priests. I haven't heard anybody say policemen, garbage collectors. And whenever I hear a reference to a category that suffers abuse, I hear politicians. Do you think that any legislation should focus on the protection of a particular group or particular groups? Well, let me ask that differently. Do you consider that this legislation may be intending to give overprotection to politicians? And I'm asking these questions very objectively because I want to get an essence as to how the public feels, the public here and the public in the diaspora. Do you consider that this legislation may be tending to offer particular protection to politicians?
I most assuredly do. And I again go to a particular, the lèse-majesté, to say it forbids the insult of the monarchy. And please note, I did not say it forbids the insult of the republic, but suffice it to say that Thailand's LM laws is amongst the most strict regulation on free speech in the world as it relates to that explicit group, that subset. If you were to say that the law of defamation currently provides for anyone, but I am one of the individuals who particularly believe that this law is for the protection of politicians and their friends.
You think so?
And their friends.
That's a criticism that you make of this legislation. Yes or no?
It is.
Yes, that's a yes.
That is a yes.
Thank you very much. And as I said, my questions are not intended to be tendentious, not to be taken a view. I want to know what is the view of the public. So, Mr. Weeks, I thank you very much.
Thank you very much,
Thank
Mr.
you,
Thorpe.
Chair.
We reverted to our
Yes.
surnames. So
The
yes.
chairman was becoming a little concerned at our informality, but we can now jointly declare that we've known each other for a certain number of years, which we don't wish to disclose. And I was wondering if the chairman recognized you as well.
We will not go there. Relative to the chairman and his lawn tennis days with his big service and knocking the ball off the court. But nonetheless, yes.
Thank you very much, David.
Thank you. Thank you.
Senator Nichols.
Thank you, Chairman. Mr. Weeks, thank you for your contribution. I just wanted to ask you a couple of questions because I'm hearing from you some criticism. You are speaking about I understand it, the provision that makes for malicious communications, correct?
I'm speaking to the cyberbullying clauses 20, 1, 2, 3, and that is what I'm speaking to. Not your particular filtering.
Cyberbullying. The provision that makes for cyberbullying, that's what you're talking about, section 20, clause 20, sorry?
Yes, sir. Yes, sir.
So this is a person who intentionally uses a computer system to publish, broadcast, or transmit data that is offensive, pornographic, indecent, vulgar, profane, obscene, of a menacing character, or causing any such data to be sent out, for the purpose of causing annoyance, inconvenience, danger, obstruction, embarrassment, insult, injury, humiliation, intimidation, hatred, anxiety, or causes substantial emotional distress to that person. That is the provision you were referring to? Largely.
Yes, sir.
Okay. And you're saying that this is trampling on rights that people have?
I'm saying that certain parts of it, certain verbs that are there included, that they are trampling on rights of individuals. Yes, that's what I'm saying.
What is that right of the individual?
The words that I'm speaking about are the words inconvenience, annoyance, embarrassment, insult. Those are the words. I made the point of putting up my fingers and using quotation marks, the visual representation of quotation marks, to isolate the words that I'm speaking about. And I'm saying that as it reads, the singular interpretations therein arising, while danger is understood, while injury is understood, while hatred is understood, I would suggest respectfully, Senator Nichols, that these words, annoyance, inconvenience, embarrassment, and insult, those words really and truly have no place within the bill.
So that a statement made to a person normally outside of the computer context that is causing annoyance to a person, is that permitted under law or should be permitted under the law?
Under the Defamation Act, I am sure.
I'm not talking about defamation. I'm talking about a statement intended to cause annoyance and disturbance and humiliation to a person.
Let me, you see, in many respects, you're asking for a qualifier for a particular word. And I am again falling back to the point of the interpretation, the subjective interpretation of these words. Annoyance, insult, humiliation. Those are not words. If I defame you, do I defame you by using an annoying word? Do you remember the words your mother's pudenda that was used within the house some time back?
Yeah, no, you don't have to keep repeating the same point you went, man. I'm not going to direct you to answer my questions, yes or no, like Mr. Thorne. Hang on a minute, Mr. Weeks. Hang on a minute, Mr. Weeks, please. Because it is very easy to say that the words are broad and vague, as some people are saying, and are subjective. But when you are crafting a law, let's just say in a more forensic term, when you are drafting a law, it has to be drafted in a way, I'm asking if you agree, that would almost capture the intention of the drafter is to capture the criminal behavior that you're trying to prescribe within the society.
Is humiliation criminal?
Humiliation is not criminal in the sense that if I am humiliated by something, but if a person intentionally tries to humiliate me with a view of something that's indecent, vulgar, profane, obscene, and menacing, there are other qualifying words within the context of the bill. Like for example, if a child or children playing cricket, and I'm sure you probably might be familiar with the game, if I say to children engaging in pre-game banter, I can let you know tomorrow, right? We bowl enough bouncers at you. That could be, as you were saying, humiliating, or it could be intimidating. But will the reasonable man consider that to be criminal?
You're coming through with a lag.
So I'm just asking, would you consider that to be criminal?
No, and that's.
So let me give you another example, David. If two consenting adults make a video of them engaging in a sexual act, where they both consent to the make of that video, and one of them releases that video to the public or threatens to release that video to the public in order to gain some particular advantage or in order to humiliate them or intimidate them into a particular position, would that be lawful in your view? And if it is lawful in your view, how could we craft the language that will allow the state to ensure that people who engage in these acts, some people might think that they're horrendous, some people might not, but generally the state doesn't get involved in the privacy of people's homes, acts between consenting adults. If it were an adult and a child, that's a different kettle of fish altogether. But when that video is threatened to be released, or to your employer, I mean, people get these kind of emails all the time, these phishing emails and stuff like that, and fall victims to the scammers on the internet from all over the world, Eastern Europe and some places in Western Africa. But if two consenting adults make a private video, which is shared between themselves, and there is some reason that they disagree or the relationship doesn't proceed in a normal way, and for example, the one party tries to gain advantage over the other, how would you find that objectionable to the extent that we should make it a crime? Revenge porn, as it is popularly called. And if so, how would we capture that other than by saying a person who intentionally uses a computer system to publish, broadcast, transmit data that is offensive, pornographic, indecent, vulgar, profane, obscene, or of a menacing character, or causes any such data to be sent for the purpose of causing annoyance, inconvenience, danger, obstruction, embarrassment, insult, injury, humiliation, intimidation, hatred. How would we capture that?
You happen to have presented something there which, mindful of the rights of individuals, the individual's rights, revenge porn falls into the area of pornography. What I'm respectfully suggesting is that as it presents itself as these individual within the context of a jigsaw puzzle, we can pick out the parts. We can be extreme. This law presents for the picking out of particular parts where you're going to say it does not have to be a revenge porn, but merely because of the fact that it did in actual fact cause an individual a level of humiliation, a level of, so there are going to be degrees. And I would turn that question back to you and ask you, when it was being crafted, was it crafted with those explicit situations in mind, or was it crafted to say, let us pick and podge that a prosecutor can choose which of these words, or the plaintiff can choose which of these words to say it caused me great humiliation.
So you're saying that a person in our society does not have the right anymore to complain when they are faced with a computer image or a computer broadcast or the transmission of data that is intended to cause some harm to them, some annoyance or inconvenience. So this is really intent of the person who posts this information online, who transmits this data, that the person who's affected by it should have no recourse in the law. That's what you're saying. Because
and to answer your question, in the way that it is posed, because of the gray area that we are dealing with, I would say yes. You cannot.
So annoying people by posting and transmitting data by a computer system that is obscene and vulgar, which is in section 2020.
You see how you what you just did.
So you made a presentation, I heard you. I just trying to get clear what you are saying, right? So in relation to section 20, clause 21, a person who intentionally is called cyberbullying. This is the one clause that you admitted just now that you had a challenge with. Cyberbullying. A person who intentionally uses a computer system to do these things, for your view, if it causes annoyance or humiliation or intimidation, then that is permissible because it could be taking it too far. So because it can be taken too far, it should not be a crime. So that the criminal acts that can occur will occur because you feel that if you were to use intimidation, humiliation, or annoyance, those would be going too far. That is your view.
No, what I'm saying is that you have expressed it, you have saw again in picking a number of circumstances. And I recognize this relative to the way that the bill is written and the comments that come out of the bill. Immediately as someone talks about it, somebody talks about pornography, and they add a particular subcategory, which is going to cause individuals who are listening to it to be justifiably angry and say that the law
okay, if you're uncomfortable with pornography, can I give another? I can give another example. I think Mr. Williams may mention that because I'm not on about the pornography thing, and I'm not thinking that is an extreme example.
I can't finish. You have not allowed me to finish, Senator.
No, but you're accusing me of doing something, and I think I have the right to clarify for the. Hold on, sir. Hold on, sir. No, sir. You're accusing me of taking out pornography. And I use the example of revenge porn. But let me give another example because I'm not have to rely on that. A school has a beauty contest, beauty pageant, Miss whatever school, St. Jude School. And one of the contestants faces emails, social media posts where, for leading up to the competition, the body shaming, fat shaming, telling them about the face and stuff, with the specific intention for that person to suffer some kind of anguish, some kind of humiliation or so. Is that permissible? Should that person have no recourse against persons going online with the intention to cause them some kind of humiliation or embarrassment in a beauty show?
Well, I'll answer your question by saying this. Sir David Simmons, when he was in the review committee, presented a 2-year-old pornographic piece of material, which he said he was prepared to share it.
I'm not. I asked you a specific question. I know, but at this stage, the members of the committee get to ask questions, and if you answer the question I asked, we'll be happy. And perhaps the chairman will allow you to expand at the end, but I just want to answer the question.
And I was answering your question by suggesting that particular circumstances, when taken in context of the pornography, the cyberbullying, there would be particular aspects of it that I could actually take a specific situation and suggest the same thing to you that you're suggesting to me. And if I ask you the similar question, you would similarly be.
Well, I asked you two questions. I asked you if a specific thing would be objectionable, and if it were objectionable, whether or not it would be, you would be able to get it into the law without using the terms intimidating, humiliation, or embarrassment, and those terms which you, and annoyance, sorry, which you have picked out as words that are too broad. So I'm asking you, I give two examples, and there could be more, because we can't sit down as a drafter or lawmakers and conceptualize every criminal act that is likely to occur in the future, particularly in something so pervasive as technology. We're talking a lot about cybersecurity, but this is about cybercrime. This is a cybercrime bill. So in drafting the bill, you accuse the legislation, the language of the legislation of being broad. And you accuse, in your answer to Mr. Thorne's question, that this was being designed in a manner so as to protect politicians, members of the political class, and their friends. So that is your view, and everybody's entitled to their view. But I'm asking you now, is the language too broad? And how would you, if the two examples I've said, revenge porn or body shaming in a beauty contest, or people playing a game of cricket and you're sledging your opponents online as young people would do with the intention of affecting how they perform in the game or something, is that objectionable? And if it is objectionable in your view, how do you deal with it within the context of cybercrime? Those are just the two questions I'm asking. I'm sorry if I had to explain the context a little long, but that is where I'm coming from.
I am hearing what you're saying, and I am respectfully saying that there are going to be circumstances where, as you have pointed out, that you can have revenge porn, you can have situations where the law needs to be able to address. But I'm also suggesting, as it currently is written, you have too far east is west. And from what I am seeing there, you've gone too far east. If you want to come down to more specifics, there are other places, other laws that you can depend on and refer to and redraft what is currently there. I'm just saying that to have it as expansive as it currently is, it is going to lead and has already started to lead to the point where dissent is being killed in my fair country of Barbados.
So if you were to, let me give you another example, Mr. Weeks. I come back in because this is my question at time. And you're making the same point again. And I'll give you another example. You receive an email which tells you that they have some photograph of you in an indecent place, or it's exposed indecently. And you need to make some deposit in somebody's Bitcoin account or send some money wire to a particular account. And you ignore that email. The email tells you this is the second warning. You ignore it. Third and final warning. Would you agree that that is an email that it hasn't transmitted anything that's offensive yet, or pornographic, or indecent, or vulgar, or profane, or even obscene, because the image or alleged image is not made disclosed to you at that point in time. But under clause 21B, this would be for the purpose of causing annoyance, inconvenience, danger, embarrassment, humiliation, and intimidation, anxiety. If it didn't come under this section, as you just suggested, what other law or what other provision in the existing law would such conduct by some troll on the internet, would that be covered in our law that exists?
Part of your example, Senator, part of your example, you dropped off a part of your example about the email. I heard part of it, but then the transmission stopped. So if you would care to just...
sorry, but I'll just try to go quickly. Somebody sends an email threatening to release some photograph or some video of you. Say, for example, we have a video of you watching porn on the internet, and we're going to send it to your work colleagues or your boss or something like that if you don't transmit some money over the internet. That causes annoyance, right? That causes humiliation, intimidation, correct?
Is an extortion, an act of extortion, and I'm sure that there are laws that provide for extortion currently within the laws of Barbados. Am I correct? You can tell me, you're the lawyer.
Mr. Weeks, sorry. The courts don't have, well, we're speaking now of the effectiveness of this legislation, and it's being coupled with the Mutual Assistance Act, which would now allow the court to have some jurisdiction over acts that affect Barbadians, even though they're not perpetrated on Barbadian soil, because of now the pervasive use of technology. So that we can talk about extortion, but if I say that a Bulgarian national is, or somebody from Nigeria, not meaning to disparage those two countries, but those are just two examples I cite, is making these demands on you. How then can the law in relation to extortion effectively deal with that situation? Are you saying then that the citizens of Barbados who may be exposed to this on the internet should no longer have, or should not have, any protection like other societies which are putting cybercrime laws in place, but because the common law in relation to extortion that has been around for centuries is satisfactory? That is what you're saying.
No, I have not. That's not what I've said. I started by saying, my first statement was that there is a need. Do not believe that I am against the laws. There are laws, there are justifiable issues. That's what I started. My first 3 minutes, I said, on the one hand, there are justifiable issues that the bill addresses, namely illegal and reprehensible acts that require the enactment of laws to protect the rights of citizens. I don't know whether you were there when I was saying that, but I
was here, and I think I could assuage some of your concerns that I too have my own issues. I've said it publicly. I've said it here in committee on more than one occasion, with some of the tightening of the language that I think we have. And I think on the last occasion, I believe that the law is a start, and that this process, this parliamentary process, which is new to us here in Barbados, can bring us the best version of the bill that is necessary to achieve that balance. And not because I'm an attorney at law, but I do believe when we don't get the balance right as a parliament, there is a body that is higher that can rule on whether that balance has been struck. And as far as I'm aware,
that is why, Senator, I was saying that I am waiting for 17 years.
I'm not getting into your individual case, because we can trace stories. You probably need to get a good lawyer. Right? If you had a good lawyer, you wouldn't probably have that problem, right? So I ain't getting into your individual case at all, right?
But is this not an individual opinion, or is not the public being invited to
you should probably
opinion?
speak to Mr. Thorne, but he's a little busy now, so you might not be able to get him. One last comment, though. You spoke about in your presentation, or going back to a point you made in your presentation about freedom of expression. And I for one, think that the freedom of expression we have in our current constitution is ample. It is well set out. It is very broad. It is a right that the courts, in my view, will interpret in a broad and liberal way, as is the norm in interpreting constitutional rights and freedoms. But the Constitution does create the freedom of expression in those broad terms, but it also creates the ability of Parliament to make laws that can be inconsistent with those rights, to the extent that they are reasonably required in the interest of defense, public safety, public health, public order, public morality, or that are reasonably required for the purposes of protecting the rights and freedoms of others. And that is something that we tend to lose, because in our zealous nature to be able to say what we want, we feel that we can just trample over the rights of people who do not think, look, or speak like us. And therefore, I will say again in this committee, any law that is brought as a limitation on one's freedom of expression that comes outside the express limitations in the Constitution, and these limitations have been adjudged over and over since 1966, when we have had these as permissible restraints on the rights. The test of proportionality is the basis on which a court will determine whether a law has gone too far. So that in our understanding of these rights, I know you can look at the American Constitution, where there are no textual or written limitations on rights. Our Constitution creates the right and also permits for laws to be passed by Parliament, who makes laws for the peace, order, and good government of the land. But those laws have to have what we call reasonable restraints. And if this bill is outside of those reasonable restraints, then I very rarely believe that people will not have a difficulty in going to the courts and having the law struck down. We have courts that strike down laws in Barbados that are unconstitutional, laws that are passed by Parliament. So that this notion that we are now all of a sudden become undemocratic by the mere passing of a bill, not even an alteration of the Constitution, but a bill, an ordinary piece of legislation cannot take away constitutional rights. And I think that the view that is being expressed to mislead people, and there perhaps may not be a proper understanding of the wide scope of constitutional rights and their express limitations in the very Constitution of Barbados. Thank you, Mr. Weeks.
Thank you, Senator Nichols. Mr. Weeks, I just wanted to clear up one point here. Yes, and I recognize when you came on, that you are who I thought you were, my senior at secondary school. I did refer to, single out politicians, but could be anyone. And I want to go back to your statement. You believe that this bill is being passed, or this legislation being enacted to protect politicians and their friends. I could have said public figures, because often these days people go online and are abusive to judges. Judges are not politicians, including the Chief Justice. So it is always easy for people to say, boy, politicians passing law to protect themselves and their friends. But I've seen many, many times people on social media abusing people who they may have been in a relationship with a short while ago, saying what Bajans would say, outing them. And they certainly aren't politicians. I don't know if they're politicians' friends. Politicians supposed to have friends all around. The constituents supposed to be their friends. So I don't know if you're including it that, but I don't believe you are. So I think that it is a bit unfair, and I totally would want to totally disagree with you that the nature and object of this bill is to protect politicians. Because at all levels, I see people on social media receive social media posts, people in all categories being cussed and abused and humiliated. So I just wanted to put that on record, sir. And even though I'm getting the impression you have difficulty not with the principle of section 19 and 20, but with some of the language in it, contending that some of the language is too vague. But that, as you said in your opening, as part of your opening, you do see the need for this legislation in principle. Is that correct?
That is correct, Mr. Chairman. And just essentially to say that it needs to be tightened up. There are certain aspects of it that they can be abused. And my concern is, yes, you do need to do this, and certainly to go back to Senator Nichols' remarks, there are certain things that you need to address. The laws have changed, the times have changed, you need to be able to address that. But at the same time, there are certain aspects of this that clearly go into a shade of gray that is extremely concerning to any and all citizens. It should be concerning to he of himself has his reservations about it. I have my reservations, and I respectfully suggest that based upon the ambit that obtains relative to justices and who knows who and how specific systems are utilized, leveraged, and otherwise abused, that this, what is being contemplated here, it will be, we will live and see. But I suggest that this is going into a shade of gray that we are going to go back and we are going to regret if changes are not made to it in its current format. But again, I thank you very, very much. I realize that you gentlemen have given me well beyond my 10 minutes, and I am most appreciative of this to make my presentation and to make my points about what should be considered. It's not written in stone. Go back to it, make considerations for the individuals who are speaking about it, particular aspects about it. The law is not, man is not made for the law. The law, I forget. Yes, man is not made for the law is made for man. That is the consideration that I'm kindly suggesting here, that some review, some accommodations for what are the general concerns of agents.
Okay.
relative to their freedom of expression.
Mr. Veach, we thank you. And you, just, you know that at the start, when you started to say about how you only had 10 minutes, so you have had 75 minutes, sir. So that's why I told you don't worry about what other people say. We make our rules. Okay? So
Okay,
we thank
thank you.
you. Good afternoon, sir.
Good afternoon.